First of all, don't miss any mortgage payments. If you miss a mortgage payment, what happens is that you get flagged, and then the servicer knows that you are having financial issues, and then they zoom in and start to mess with you to try to push you along to foreclosure. If you have missed a mortgage payment, you should try to catch up as quickly as possible. You should not miss mortgage payments hoping to get a loan modification. Many people try to get loan modifications now when they have sufficient equity in their house to refinance, and the bank is just going to string you along until you are in default long enough for them to prevent you from refinancing. So if you're missing mortgage payments, you should look to either refinancing with another mortgage, maybe with a lower interest rate quickly before you ruin your credit by missing payments to your servicer, or you should look to downsizing. Maybe it's too much house. Missing a mortgage payment is not a good idea to begin with. If you do miss a mortgage payment, you should figure out how to pay it. The problem is that people expect their mortgage servicer to help them, and when you start missing payments, the mortgage servicer just swoops in like a vulture because they're not there to help you. Their business is foreclosure, so once they see you missing mortgage payments, they're going to swoop in and help you along. They'll offer you a loan modification, tell you, keep sending us letters. They'll let you get into a longer default. I guess the best thing I can advise is if you miss one mortgage payment, try to make it up. Don't look to the servicer to help you. Don't miss multiple mortgage payments, and quickly resolve it, because the more you miss, the more likely that you're going to go into foreclosure. So the notice of default is the first notice that comes. Then 3 months later, you're going to get a notice of sale, and then a sale that will contain a sale date, and then your house will be sold 21 days after the notice of sale. So if you receive a notice of default, you are on the railroad tracks heading towards foreclosure. And what you want to do is you want to find out from the servicer and the trustee what is required for you to reinstate the mortgage. Okay, don't rely on the notice of default. Make sure you get an actual reinstatement, and that's not a repayment. You're not repaying the entire loan, but a reinstatement. How much will it take for me to get this loan current? Okay, make sure you get a window of time. Make sure you get wiring instructions so that you can pay the trustee that amount, and then do everything you can to make sure you pay and reinstate your mortgage. If you allow it to go to sale, the only way to save it is a bankruptcy, at which time you'll have to pay that money back anyway on a Chapter 13. What I always advise people is to just not let yourself get into default. The thing about once a notice of default is recorded is then they've affected your credit. So they've affected your ability to go other places to get a refinance. So you want to try to keep those payments current and not get to the notice of default, because once that happens, you're headed towards foreclosure. If you feel that the servicer has overcharged you on the notice of default, pay them anyway, deal with it later. Okay, don't go back and forth disputing payments with the servicer while you're building up more and more default. Pay them, and there's always small claims court. Well, tell them to leave you alone, first of all. No one has a right to be on your property without your permission. If you're having investors coming, they're swooping around, it's probably because your house is flagged as a foreclosure property, and they're looking to try and see if they want to buy the property at foreclosure sale. I mean, you don't have to let them see your home, but it usually means something is going on. It may mean also that somebody tricked you and the house has already been foreclosed. So check your county records as quickly as possible to see what happened, because even if the foreclosure occurred a few days before, there's still some things that you can do immediately after the sale. There's some things that you can do. We'll talk about that, I guess, at another time. But if you see that happening, check your county records and find out if there's something happening on your property. We call these sleepy seconds. So what happens is investors buy these seconds on the secondary market. Some of the worst ones don't bother to send you any notices. They just come and record a notice of default and a notice of sale. There's different levels of investors and there's different strategies that they'll use. But the bottom line is if you get that second deed of trust comes calling, you have to pay them. The reason they sat on it for 10 years is because they bought it when it was underwater, or somebody bought it when your house was underwater and held on to it like an investment until the equity came back in your property, and now they want their money. So the best thing to do is to try to use the only leverage that you have, which is money now instead of bankruptcy. Because you have no choice but to pay them. It's just a matter of how much. And most of these investors would prefer to get a cash payment immediately rather than have to have you reinstate the mortgage, put you on a payment plan, or have to fight you in a bankruptcy. So use that leverage, which is the tiny bit of leverage that you have, to try to get them to accept a sum in one lump sum. But you do have to pay them that loan. Those loans don't go away. There is no statute of limitations on a mortgage. You signed a 30-year term, so for 30 years they can collect on that mortgage. And for 30 years, they can collect on that second. And yes, the second can come and foreclose, even if they haven't notified you in 10 years. There's no statute of limitations on that second. Those seconds don't go away. Okay, so there's two words that get used a lot in real estate: deed and trust. And somebody asks the question, what is the difference between a grant deed and a deed of trust? So a grant deed is what you get when you get title, which is very important. A deed of trust is a mortgage. In California, we don't have mortgages, we have deeds of trust, although the word mortgage refers to both a mortgage and a deed of trust, which is a little bit confusing, but a deed of trust is a mortgage. What makes it different than a regular mortgage is a regular mortgage will just have a borrower and a lender, and the deed of trust has a trustor, who is you, who's the borrower, a beneficiary, who's the lender sometimes, and then a trustee, and the trustee holds the property in trust for the duration of the time that the trustor is paying off the mortgage until it is satisfied, and then the trustee conveys title to the trustor. The other thing about a deed of trust is when we have deeds of trust in California that include the power of sale in the mortgage. So deed of trust goes along with non-judicial foreclosure, which means that literally what it says, non-judicial. So the lender, mortgagee, servicer can foreclose without going to court. Just notice of default, notice of sale, sold. That's non-judicial foreclosure. That's based on the power of sale in the deed of trust. With a mortgage, the lender beneficiary has to go to court. That's judicial foreclosure. So it's much better for the borrower, because I think that's how they have it in New York and some different states throughout the country. You can go into court and challenge the lender right to foreclose, challenge standing to foreclose. In California, we can't do that. We can't challenge standing to foreclose until after the foreclosure has occurred. When you have a deed of trust, there's a lot of rights and responsibilities that are attached to that. This is such an interesting question, because I can't tell you how many times people come in and they say, I thought it was just a flyer. I didn't recognize the name. But if you have a second deed of trust and they've sold that deed of trust like 15 times between different investors, wearing white shoes at the golf course, you don't know who your investor is. If somebody's sending you a flyer or a letter about your house, about your mortgage, don't ignore it. Okay, there's plenty of attorneys that will look at the flyer or the letter and explain to you what it is. It's not worth it to fool around with your investment, which is your property. Come and see a lawyer, come and see me. I'm happy to look at it and ask me, what is this? Okay, figure out what it is. It could be something. Oh my gosh. There's many ways. It depends on how you got to that situation. If it's by your own default, then the best thing to do, if you're right up to the date of the sale, the best thing to do is to do a bankruptcy, stabilize your situation, and then get on a payment plan through the Chapter 13 to pay those arrears over 60 months through the bankruptcy. That's basically a shoving a loan modification down the mortgage servicer's throat, is how I like to describe it, because they won't give it to you voluntarily, but you can force them to take it in the bankruptcy. The other thing is, people get into foreclosure through all kinds of situations. Like, you may have a parent died or something, and you're left with a foreclosure, and you're trying to start a probate. Speak to a probate attorney that is willing to hustle, do some work, because once you have a probate filed, you can do a motion for an order to sell the property. If there's sufficient equity in the property, you can stop the sale while the probate proceeds, as long as the servicer and the lender are guaranteed to get their money, and the probate court will issue an order to stop the sale. If you can pay them what you owe them, then you should do that. There's a statute that only allows you to pay them up until 5 days before the sale. You would think that they would be happy to take your money up to the day of the sale, but that's not how it works, because they don't want your money. They want your house. If you don't get that money to them 5 days before the sale, they're not going to take it. So you have to get the repayment amount, the official repayment amount, not the one that's on the notice of default. You have to get a window of time when that is good, and then you have to get the wiring instructions, and then beg, borrow, or steal, whatever you have to do to get the money, and pay them that prior to the foreclosure sale date. 5 days prior to at least to the foreclosure sale date. First, you miss some payments. The bank sends you a letter. If you're missing payments on your primary mortgage in California, they have to send you a letter to try to help you. Not that they're going to help you, but to try to offer you some kind of alternatives to foreclosure. That usually takes a few months, maybe, so you can miss maybe 3-4 mortgage payments. They may, depending on the equity in your property, I mean, if you have a huge equity position in your property, they'll let that go forever, because they're sitting pretty. They're in control of your property. They're in control of your equity. So go ahead, sit there, live off your equity for 6 months. The bank doesn't care. Not advisable. It depends between the missing the payments and the notice of default. And depending on your equity position, it could be anything from 3 months to 3 years. Bank is always aware of your equity position, and they never let money sit on the table. So don't underestimate that the bank is watching every penny. Once they do decide to foreclose, they record a notice of default. Things happen pretty quickly. 90 days after the notice of default, they record the notice of sale. The notice of sale has a sale date within 21 days. And if there's nothing done to stop the sale or to pay them back, that's what happens. It'll get sold. And some investor will reap the benefit of your equity instead of you. Don't let that happen. What kind of lawyer do you need if you get a foreclosure notice? You need an honest one. You need a person, an attorney that specializes in foreclosure, which there aren't many, because it's exhausting and stressful and painful to watch people struggle and be so scared and stressed, and involves a lot of work, not for the lazy. You have to be careful when people make you big promises. All of the advice that I give is warning people not to miss mortgage payments, warning people about the mortgage servicers and how difficult it is to beat them. Okay, so when you get some arrogant attorney that's telling you, I'm going to save your house, I'm going to turn this sale around, I know how to do this, I've done this a million times, that's not really how it works. There are things to do at every stage of the process. For instance, if you come to me right after a foreclosure sale, there's some statutes designed to pull the house back from an investor, but you need somebody who knows basically the timeline of foreclosure and what are the remedies that you can use at every step of the process. And they're different, they change. There's different things you could do before, less things, but still some things that you could do after. Just go to somebody who specializes in foreclosure. That's very interesting. Well, in California, we have non-judicial foreclosure, which means that they don't have to take you to court. There's no personal service of the foreclosure notices. So all that has to happen is something in the mail. They send you something in the mail. Maybe they post it on the property that says notice of default. 90 days later, notice of sale. 21 days later, sale. Okay, so when you think about it, Maybe you were out of town when the notice of default was sent to the house or when it was posted on your property. Maybe you looked at it, didn't know what it was, and just threw it away. Sometimes you could be maybe you're in foreclosure because you lost someone, because you're grieving, because there's some trauma, there's job loss, there's anxiety, there's stress, and you're not looking at your mail. These are human reactions, right? That's how you could be subject to a foreclosure sale without you knowing it. Once you start missing mortgage payments, the bottom line is high alert. Check every piece of mail. It's so easy for the banks to foreclose, number one, because we have non-judicial foreclosure in California, which means they don't have to go to court to foreclose on you. They can send you a couple of notices, and that's it. They don't even have to personally serve those notices on you. Just send them to you in the mail. Notice of default, notice of sale, sale. That's it. Property sold. The other reason why foreclosure is so easy is because there's a lot of case law that has developed over the last 20 years that make it super easy for the banks. For instance, there's something called the show me the note argument, which is people trying to claim that the bank doesn't have the right to foreclose because they don't hold the promissory note. They don't have standing to foreclose. But there's case law in California that says you can't use the show me the note argument, because even if the wrong person is foreclosing, you cannot sue them for wrongful foreclosure until after the foreclosure happens. So it becomes very difficult. So basically anybody could come and foreclose on you with a forged deed of trust or forged promissory note. It's up to you to sue them after the fact. And this is a leftover benefit of the powerful banks that control our government, our case law. That's how.